About the forum. Here we workshop the papers of early career and junior scholars, people who are primarily working from South Asia or broadly on South Asia. And today we have an exciting presentation. We have our presenter, Ashwani Singh, who's a legal researcher and he's just completed his LLM last year. And for our discussion, as our discussant, we have Gautam Bhatia, who's an advocate as well as an adjunct professor at the Jindal Global Law School. We all know him as a constitutional law scholar as well. Ashwani's paper is titled Constitutional Directives as Incrementalist Tools for Constitution Making in Deeply Divided Society. So without much ado, we are going to begin our workshop. Our format for today, Gautam, you can speak for about 15 to 20 minutes, following which Ashwani, you can respond directly to the comments, and then we will open it up for a wider discussion. Over to you, Gautam.
Yeah, thanks. Thank you for inviting me to comment on this paper. This paper examines a much discussed issue in contemporary constitutional scholarship, which is the nature and the role of directive principles or constitutional directives, which began as a constitutional concept in the Irish Constitution, then extensively borrowed in the Indian Constitution, and of late have been appearing in various forms in more modern constitutions following the second or third wave of constitution making, depending on where you start your counting from in the 1990s. The core argument of the paper is that as opposed to Constitution's general goal of bringing about a certain kind of revolutionary change, constitutional directives or DPSPs perform a more incremental role. They are needed and they perform a role in certain kinds of contexts. So one, as the title suggests, is in the context of deeply divided societies where there is a deep kind or degree of ideological disagreement about certain norms or certain principles. In that context, directive principles perform what has often been called the role of constitutional deferral, which is that in order to avoid deciding that deeply divisive question one way or the other, they, by using the language of somewhat abstract norms and by making it clear that these norms are not enforceable in court, they leave it to political settlement for another day. And in that sense, they diffuse that deep ideological disagreement through a strategy of deferral. So that is the goal that they serve. It is not simply what we formally understand as directive principles that play that role, but other parts of the Constitution as well. So in the paper, for example, the Constitution's language provisions are understood as performing that same function with respect to deferring a particularly controversial or divisive issue to another day, and with the idea that in the fullness of time it will be politics that will resolve that disagreement, in what might be a non-zero-sum manner than the more binary path of litigation and court judgments. So that is, in a sense, the core argument that is made in the paper, and I have a few comments, that perhaps will pave the way for deepening some of the ideas or the arguments here. So to begin with, the title itself as Incrementalist Tools for Constitution Making in Deeply Divided Societies. So I think that, there are two terms here that are doing the work, right? So one is incrementalist tools and the other is deeply divided societies. So the first, and the two are connected, right? So on the first issue, what do you understand by directives as being incrementalist tools? And in the paper, this is set against Constitution's general revolutionary purpose. So I think that idea may need to be interrogated a little more, because actually there is a strong argument that both the Irish constitution, from where these principles do their original life, and the Indian constitution were not revolutionary documents or did not intend to bring about revolutionary changes. Of course, they sought to bring about a political transformation in the bare sense, in the sense of a transfer of power. But at the same time, they left large structures and large facets of the pre-constitutional design untouched. So, in that sense, the Constitution as a whole, as a document as a whole, is itself an incremental document in a certain way. And as Hannah Arendt has said, it's basically, I mean, the Constitution comes at the end of a revolution. It's meant to contain revolutionary impulses more than anything else. Now, of course, that might be a bit complicated in more recent constitutions that are explicitly, call themselves or refer to themselves as being about these widespread changes. But that might not be so true for the Indian Constitution. So, in that sense, when we refer to directives as incrementalist tools in the context of a broader constitutional structure that is non-incrementalist, we may need to think more carefully about whether the Indian Constitution, what kind of a document it is as a whole, and in that sense, are directives actually set apart from the rest of the constitutional vision, or are they just simply another way of accomplishing the same overall incrementalist or even at certain times conservative vision? So that's the first point. The second is the other term, deeply divided societies, and the argument that that directives are meant to perform, as the title says, the constitution-making role in a deeply divided society. So there are the two things here, right? So one is that if you actually look at the provisions of Part 4, there are, of course, the ideological ones. The cow slaughter provision, for example, of course, stands out, and the Uniform Civil Code. These are the obvious ideologically loaded or freighted provisions, and you have the debates that you can understand them in the context of. But a large number of the provisions of the directive principles are actually not ideological in the sense that they, in the sense of referring to that division that the article talks about. So, as a matter of fact, most of the provisions of Part 4 are actually to do with labor rights. Various kinds of labor provisions that are meant to safeguard the rights of labor. And the history of the framing reveals that the reason why you have these provisions in Part 4 is because at the time there was the belief articulated most clearly by B.N. Rao that these are non-justiciable because they require a certain kind of resource commitment by the state. Your classic distinction between first generation and second generation rights. So that was the reason why they were put in the non-enforceable category. And then, of course, the march of constitutional thinking over the years, and this is referred to in the article, now brings us to a point where socioeconomic rights, the kinds which are found in Part 4, are enforceable, except that with caveats around progressive realization and so on. So, but that apart, so then that raises the question of the character of Part 4 itself, and that Part 4 of the Constitution is not a homogeneous section. Different provisions are there for different reasons. Some might well be the result of deferring an ideological disagreement, whereas some actually are there because the framers, were proceeding with a certain belief about what kinds of rights are enforceable and what kinds are not enforceable. So that perhaps would prompt us to think a little deeper about the overall internal coherence of Part 4, and indeed, by extension, the overall internal coherence of the Constitution as a whole. And is Part 4 responding to a specific problem, or is just that it was in a certain way the repository of a number of different imperatives, and we may then have to narrow our analysis to certain kinds of directives and not to the idea of a directive principle that is not enforceable by the court. And in fact, I think that the article sets us along a path of thinking in that direction by then referring to a non-DPSP, which is the language provision, right? And so we then may not be thinking about this as an issue involving directive principles as understood in Part 4, but a certain set of provisions or a general technique of constitutional deferral that is accomplished in different ways, either by formally designating something as a directive or by some other way. So that might be something worth thinking about. But also the second point there is that when we speak of deeply divided societies, I think then the question is, in the Indian context, what exactly was the division that was there in the Constituent Assembly, or for that matter, if the Assembly was responding to divisions in society, because it's worth remembering that at the time of the framing, the partition took place in the middle of the framing process, and the Muslim League had left, and the socialists and the communists were not joining. And so essentially, as the historical records show, the Congress party had a hegemony over the drafting process and enjoyed a degree of popularity in the larger newly independent country. So it wasn't it wasn't a case like that of, say, Lebanon, or even less spectacularly a case like Belgium or Canada, where those lines are so clearly drawn or so clearly visible, specifically in something like the UCC or Cow's Daughter. Whereas you can say that the language question, was definitely deeply divisive right from the beginning, and soon as independence began, you had, those language movements, and even before 1930s, you had those language movements, which were actually a genuine threat to the integrity, the physical integrity of the newly independent state. I think we may need to think a little deeper about to what extent or what are we talking about when we talk about the deeply divided society in the case of directives like cow slaughter or UCC in the 1940s. Right? So who was the division there between, or who were the contending parties? And it was actually just a deep, as deep a division. Is it your classic example of a case where you have to defer something to prevent an explosive situation, mass violence, or was something else driving was something much simpler, which is just a failure to disagree or to agree in the assembly itself, right? Because that is something different from deep division in the country as a whole. So are the directive principles actually responding to that kind of deep division, or is it just responding to failure of consensus in the assembly and therefore parking issues for later resolution? Right. So the last point then, and then I'll close, is that there is, of course, a lot of argument on the point that directive principles were not about incrementalist tools for constitution making in these societies. So there is scholarship, talking about how the underlying, idea of the chapter, which explains most of the principles, is that the belief that there are important principles for governance, but are not subject to judicial resolution or litigation to resolve or to enforce through the litigation form. And in that context, you have the whole history of the court moving from step to step in the DPSPs, which is beginning with first 10 years of clearly stating that they're not enforceable, and then a tradition of the court over the next 20 years that says that, okay, they're not enforceable, but if there is a law that is meant to further a DPSP, then it is by definition in the public interest. And therefore, under Article 19(6), the public interest prong is fulfilled without further argument. So then it creeps into Part 3. And this is, of course, combined with the fact that around this time, the political rhetoric is one that the DPSPs are meant to bring about the socio-economic transformation of the country, and Part 3 is standing, in the way of that. And so therefore, there is the attempt to amend Article 39 and so on, Article 31C, which is, of course, partially struck down in Minerva Mills. But the point is that the political or the executive-led understanding of Part 4 then is not so much about deeply divided societies, or focusing so much on the UCC as a directive principle or cow slaughter, but actually talking about the clash between the individualistic fundamental rights and the more communitarian goals of an equal society under Part 4. So that being the case, then that story has to play some role, even if the belief is that that's not how you characterize Part 4, and actually this is the better way of understanding it. That entire trajectory should play some part, even if it is to say, okay, this is one understanding, but this is not the most convincing understanding of what Part 4 is doing. And of course, then the final stage where the court then, starting from N.M. Thomas's case, uses Part 4 as a way of picking between two possible conceptions of the same fundamental right. So if you're looking at the equality code as being either formal equality or substantive equality, then N.M. Thomas tells you that because of Part 4, an understanding of equality which is substantive is more true to the constitutional vision than one that is formal. So that role that is played in a number of cases completes that judicial story of going from non-enforceability means not taking cognizance of Part 4 to a point where Part 4 then plays an integral role in understanding or interpreting what Part 3 actually means. So that story is kind of missing from this piece, which I think if the piece intends to be, advancing one particular argument for how we should understand directives as they, exist in the Constitution, should take into account, the countervailing stories as well, and then address them or engage with them and to say, look, either that this is one story and there are multiple stories, or that this story is obviously a more convincing one than the others. So that should generally be, something that the piece engages with. And I think finally, of course, I think that the contribution, interesting contribution here, is to take the argument beyond Part 4, and I think the language discussion on the language provisions there is very valuable, because that actually shows us that the techniques that are used, as I said a little earlier, could be similar, but the constitutional form that they take may be different. If it is, for example, cow slaughter or UCC in Part 4 or language elsewhere. So I think that argument is one thing is worth building up further and perhaps providing a broader theory of how different constitutional forms can play the same goal in this broader goal of constitutional deferral to resolve political conflict. So I'll stop at that and hand over at this point.
Thank you so much, Gautam. That was very, very comprehensive. And I'm sure Ashwani has much thoughts and responses to share. Ashwani, over to you.
Hi, thank you, Rohini. Thank you so much, Gautam, for extensive comments. Some of the comments require more deep engagement, so I will just refer to them and leave it for for later work. But there's a couple of clarification on sort of how I understand constitutional directives or directive principles, and whether the paper actually engages with Part 4 per se or directives in general. So in the paper, I take a point with respect to Part 4 that they are not homogeneous in character. They are different. You mostly have socioeconomic rights, as you mentioned rightly, and and you have also sort of written earlier on this that they are supposed to contain and give sort of a concrete shape to fundamental rights. That's also how we understand directive principles. So I see that point, and I'm not disagreeing on that point. My argument here is not that this is just the only way to look at directive principle, but to see that. So I come from I sort of take Lerner's argument that okay, incrementalism could be a way to engage with deeply divided foundational issues, right? In deeply divided societies, and she sort of mentioned a few sort of designed to sort of constitutionalize those foundational issues, whether it could be putting in abstract uh, provisions or contradictory provisions, and one of the examples is directive principles, even though sort of she only sort of talks about with respect to UCC, and that too in a very sort of limited sense, in the sense in the sense that she doesn't actually give an account of what actually makes directive principles an incrementalist design tool, right? Which is what Khaitan has focused on, right? He has sort of given an account of why they are good incrementalist tool. So my argument there is that okay, they may have other values and there may be other reasons for adopting for sort of constitutionalizing or maybe a socioeconomic rights or some other uh, principles in form of directive principles. But here is also here is also here is another value of directive principle that we can sort of employ when needed. It's not that we have to. It's only when we are sort of frameworks are faced with a deeply contested foundational truth. And my argument there is now you sort of rightly point out whether it's more ideological differences, deeply seated ideological differences, or rather are just sort of or it could be because they're not able to reach a to a consensus. Now, I understand on this point it needs a bit more elaboration. At this point, the paper is not very clear on that. But at least I could say that they're definitely sort of important in addressing ideological disagreement, because those disagreements come from a very sort of deeply seated sort of understanding on how we see society, right, or constitutions per se, or what they do, and we are sort of very difficult to move someone from a, sort of a deeply contested position to sort of a more convincing or a position where they could reach a consensus, right? So that sort of your there's sort of so the diagram is but definitely sort of a way to sort of address those ideological disagreement. It could also be used, for example, uh, when they're not able to reach consensus. But then I understand this on this point, it needs more a bit more sort of clarity on how they're sort of different from ideological differences, because right. So it could be like I think this is where sort of my sort of argument on decision cost and error cost comes into play, right? So it could be and this is sort of I'll leave it for more engagement later on, but I could sort of briefly sort of mention here that it would then come out to whether the issues uh, are so sort of foundational that the government cannot function without them. So for example, Leonard mentioned that even though you could defer some foundational issues, you cannot defer uh, you know for example, you cannot defer whether it should be a parliamentary government or it should be presidential government. You cannot defer the structure of the government, which would make the government sort of the constitution functioning. So uh, I think that's where I could sort of that's one thing where I could not use directive principle to address a disagreement. But yeah, it needs a bit more elaboration. So I'll leave it that for later. Uh, with regard to just one second. Right. Just one more point with regard to sort of So I understand that, which I also mentioned here in the paper, that even though they were not justiciable when they were, when the constitution was in force, but the Supreme Court has sort of found a way to sort of give effect to those directives. But I have also addressed here that that's not true for deeply contested directives. So I've used the word deeply contested directive to refer to those directives that address deeply contested foundational issues. For example, here it would be UCC and language directive, right? Now, even though the court has enforced the directives, those directives are mostly socioeconomic rights, or as we largely understand, second generation right, where the court says that they could be used to contain or give a shape to fundamental rights. All the judgments on UCC I've mentioned in the paper also have, whenever they sort of say that the court has sort of a duty to implement UCC, they very clearly state that they are not directing the state to do so. It's up to the state. So it's the the government are not are not directing the state. It's more of a they're sort of reminding the state, okay, these are to be taken care of. Whether they do, whether the state does or not, is not important for the, at least for this paper. What they also do is that what I mentioned in the paper is gives political force to directives, right? Which Ambedkar also pointed out during the assembly, that even though they do not have legal force, which you also have mentioned in your paper, that they have some kind of force which could likely be, and it's likely that that Ambedkar is referring to political force, because the people could sort of pressurize the government that, okay, you have to implement this, right? It could be a political agenda for parties, right? Which we now see that has come true. Now, please sort of, if I'm going beyond the time, please let me know. And so that's where sort of that's one point I was sort of emphasizing. But yeah, I agree that some of the points that Gautam mentioned needs a bit more engagement. I need to sort of clarify a bit more on what I understand by deeply directives, deeply divided societies, and how sort of India fits in there. Just one last point, that I understand that constitutions could be incremental as whole, because they are obviously they are as we now understand they are sort of mostly it's globally sort of accepted that they have transformative value, right? They are living tree, right? So in that sense, they definitely have the incremental value. But by incremental, I'm not just referring to sort of I'm not referring to those aspects of constitution that that leave scope to the political organs to fill in, to expand on what's there in the constitution, to give meaning to what to constitutional provisions. But I'm very specifically referring to intentionally, and principles which are very intentionally put in there, so that the foundational issues are transferred, not transferred from the constitutional domain to political domain. And here in this paper, I'm highlighting directives, and I'm sort of saying that I have a very small couple of pages on why they are better tools. I pick it from what Khaitan has argued and expand on it. I have one disagreement as to with respect to Khaitan's argument and Lerner's argument, which is, I think, is important to point out here, is that so Khaitan, so Lerner believes that it is the non-justiciable character of the directive principles which give them, which makes them better incrementalist tool. Khaitan, on the other hand, believes that even though non-justiciable character is important, it's the programmatic character which gives them, incrementalist value, because he believes that because the directives are not realized the moment constitution comes into effect, and they require some kind of act from the government, and often a multifaceted approach to implement those directives, right? So I sort of, now my argument here in this paper is that both these values are equally important, and not just important, in fact, they complement each other. And this is I have sort of supported with respect to UCC and language directive. I think I've been speaking for way too long, so I'll just shut up here. And thanks so much for your comment. And just one more point that just which I did not say it earlier. Thanks so much for JFF for organizing this. I've been attending JFF session for a long time, and they have been sort of very helpful in sort of understanding engaging with scholarly work, and sort of have learned a lot from previous presenters as well. Sort of a huge thanks to JFF and all of the previous presenters that for sharing their work. So thanks a lot.
Thank you, Ashwani. You have time. Both of you have been very concise, and we have close to half an hour for a longer discussion, so don't worry. On that note, shall we open it up for questions or comments from anybody else? If you have any questions, you could raise your hand, or if you have comments, you could type in the chat. True to its form, Teams has not been very kind to us today, but we're still here so far. If no one's asking a question, I will take advantage of my position as a chair. I am not a constitutional law scholar, so there are different ways of reading any piece. Any insight I offer to you is from the perspective of a critical legal studies scholar reading a constitutional law piece. So I have a couple of questions. The first one is, who's your reader? Who's your audience? The reason I ask you this question is because there are parts of the paper where you jump in with the assumption that certain processes and certain terms are already known to your reader. And it might be a little helpful to perhaps, if not offer a definition, at least offer some sort of a working, functional definition of what is it that you're working with, and right from the beginning till the end of your paper. So it assumes that your reader has some kind of constitutional law knowledge, which may not be the case in this instance. This is more stylistic than anything else. My second question, a comment, which was partly addressed by Gautam as well, is it might be helpful to introduce a certain kind of socio-legal context to your paper. And this I primarily say as a CLS scholar. Your arguments, while rigorous, are very clean. And I don't think constitutional or political processes are that neat. So the messiness of the context, where the divisions come from, and as Gautam said, some issues have a tendency to be more polarizing than others. And how is that significant within the overarching argument that you're making? Also, the illustration and the example that you choose to speak of deferral thereafter, that might be interesting. So not to make this socio-legal history paper, but offer some categorical context of why is it that you're choosing to discuss this and how that bears on the framing of the arguments for you. My third comment has to do with perhaps a little more case-based illustrations of the points that you're making. So here and there you speak of how judicial review sort of plays this counterfoil, but don't necessarily offer an illustration. Similarly, when you're talking about the political force of directive principles, it would be nice if you could demonstrate some process that indicates how this political force accumulates or how it accrues, or what do you even mean by the term political force? Because I imagine the term would mean different things to different people. So those are some of my observations. Does anyone else want to jump in, or do you want to respond to some of those?
Thank you for your comments. Yeah, I understand one point, which also concurs with what Gautam pointed out, that probably the paper doesn't show the messiness of the issues involved, right? How messy they could be. So I would work on that, amend the paper to to recognize the mess, if I may say. And also with regard to definition, so I could do that. I think, yeah. So I think even though I do not give a definition, for example, of political force, I do give at least an idea as to what it could mean. For example, so here, I'm not finding the exact paragraph where I mentioned, but for example, I've mentioned here in the paper that the even though judges cannot enforce these directives, and they should not enforce the directive, the fact that they talk about it and the fact that they could remind the state that there are these directives that need to be taken care of and you have to respond to these directives. They keep the democratic value of directives alive by reminding not just they're not that reminding just the state but also sort of reminding the people as well that okay, this is something that the state has to do. They have not been done. They had not done it yet, and sort of so so there's sort of so it's like picking something which has been dead for a while and sort of giving it a life. Okay, that you have to sort of now it's your job to sort of take it, sort of give it the to sort of strengthen, I could say, the force of directives through sort of election or whatever. Now, one clarification which I think one point that a question also, in fact, of Gautam and to you. So, for example, sort of I see that most of my sort of the paper largely relies on language directives, and which is different from sort of at least because they are in different chapters, from directive principles, the part 4. So they sort of also sort of engagement sort of sort of recognize that difference and say how sort of how language directive also sort of similar to directives that we have in part 4. I've been sort of thinking about that, but sort of also I think so do that, but let me know if you have thoughts on that. Plus, what else? This also sort of reminds me of one point that what Gautam mentioned, if I may go back to that again. So, this I'm sort of, when I say at least with regard to Indian context, and this I sort of, so on page 29 of the paper, I've mentioned Khaitan sort of argues that it's not the structure of, it's not the form, but that is the structure which is important, right? So just give me a second. So here sort of in sort of, yeah, so he says that whether a norm is right or direct depends on the structure and not sort of where how the constitution sort of characterize it, right? Whether sort of, so there could be, and this is why sort of I've also mentioned in the initial in the paper that there could be other constitution could also, there are sort of at least 37 constitutions which expressly recognize directives, but there could be other constitutions that do have directives but did not categorize them. Such principles have such provisions as directives. So because it's not the sort of how they are sort of, whether they are sort of recognized as directives is what matter, but rather the structure of the directive, which I think Khaitan's work has been sort of excellent on that point to identify what gives them directive. Though I have sort of one disagreement as to what they are sort of, which I mentioned in the paper. But so if we take that point of view, as it's that language directive fits in that in that it's not a it doesn't give a right to the state to sort of enforce, for example, to give to make Hindi the national language, right? It is not sort of clear on that, okay, that you could the Hindi is now a national language, or it is not a right that someone could go to court and ask that a state to declare Hindi a national language, right? So it's just a directive which the state could or could not do, right? And yeah, that's all.
Do we have
Is there time
another question?
for another
Yes,
question? Yeah, sorry,
absolutely.
can you hear me? I'm outside, so I don't know if you're able to see or hear. Thanks. Thanks. And this is a question, I think, to Ashwani definitely, and Gautam, if there's time for this. I'm not a constitutional lawyer at all. This was really interesting for me because I'm also looking at the power of Article 39A in my research on legal aid in India, and which is why this is very interesting for me. It's an very good introduction for me to understand directive principles. I wonder, and this is something that Ashwini you've written in your paper, and don't really talk much about later, and maybe for a good reason, which is the idea that there are other deferral tools. I think you make a reference that this is just one, and in one part of the paper you kind of justify, and you explain that there are also bylaw clauses which to you are not an alternative, right? They don't do the same thing, which is why you can't argue that they are also a deferral tool, if I've got that argument right. So, I mean, you say that they don't perform the same role as the directive principles, and I wonder if you can then extend that to say they're not a deferral tool. I wondered, so two things. One is more a stylistic question, and two is an actual clarificatory question. The stylistic one is, why are you suddenly introducing bylaw clauses in the paper? Was there some reason for it? Was it to answer a question that you wanted clarity on? But secondly, and more importantly, what are these other deferral tools? Are directives the only ones?
Gautam, do you have to add sort of?
No, you go ahead first. I'll go after you.
Oh, great. Thank you, sir. Thank you for the questions. Yeah, sort of. Yeah, I mentioned sort of by law clauses. I think I have to expand on that part of it. Sort of, I'm thinking sort of to give more sort of space to that argument, to engage with other deferral tools, and so how directive principles, how sort of how directive principles work, as against other sort of, when compared with other deferral tools. And bylaw clauses are deferral tools. In fact, Rosalind, if I mentioned some papers here, Professor Rosalind Dixon has written on it, bylaw clauses, and Tom Kinswork as well. They are good deferral. I'm not saying that. But I'm just saying that when we sort of pitch it against directive principles, bylaw clauses are sort of, you could say, not so strong, and which I have mentioned in the paper here, that the directive principles are not just are more of a, they defer it partially, so it gives the framers some more scope to contextualize the problem. So it could be so. So for example, if there's a question, or for example, language directive, right? So if there would be a bylaw clause, which there is in Article 343, it says that that Hindi and English would both continue for English will continue for 15 years, and after that, if unless the government extend it, English will not be an official language, right? So it's only for the next 15 years, and thereafter it will depend on the government whether they want to sort of extend Hindi as an official language, which the government did, right? Now, bylaw clauses will put a time limit that, okay, this is, there's a time limit for you to act or not act, right? Directive principles gives you more freedom as to what what the government and what the political organs could do, right? So in that sense, they they give the framers better better tool to customize the problem as to, for example, that, okay, the state has, for example, the language directive, which says that the Hindi, that the government could, the government has the duty to develop Hindi, right? But not in contradiction with other forms of Hindi, right? That's the language directive there. And the reason for introducing bylaw clauses, which seems abrupt, because until then I had not talked about bylaw clauses, right? Is that because they were used for language question as well, for 343, right? Article 343, and we also have a directive on language, and the reason was that when we see these two provisions, it's Article 351 which does have your job, which was that because during the Constituent Assembly, at least from my reading, the contested issue was not that whether English would be an official language or not, but whether was firstly there was sort of a very good consensus, at least on that English should not be a sort of an official language for good, right? It should be, earlier the understanding was that it would be there for 5 years. Some arguments were there for that it should continue for 15 years, but there are no sort of there's no sort of good consensus on what would be a replacement, whether Hindi should continue or whether Hindustani. There was sort of strong, not not great in terms of number, but very strong argument for Hindustani. But then there's again no clarity on what Hindustani means. Whether it's some said that okay, it's Urdu, it's Urdu. Some said it's Hindi and Urdu. Then there's an argument that okay, Hindi is fine, but then what is Hindi? There are different forms of Hindi, different styles of Hindi. So what do you mean by Hindi, right? So the language directive in that sense does the much heavier job in recognizing that okay, Hindi could have different forms, different style, different expression, but when the government does develop Hindi, it should not do it should not do that development at the cost of other forms expression as used in Hindustani or Sanskrit or other languages. Now, this is why sort of the reason for introducing bylaw clauses there was to sort of say that okay, bylaw clauses is good, is fine, but then they have a very limited role in terms of deferral, and also a very sort of minor disagreement with sort of Dixon was there was that UCC in one of our papers frees UCC as a bylaw clause. If I'm not wrong, if I'm wrong, I'm so very sorry for that. And that's and I think it should be more of understood as a directives, the way sort of I have sort of mentioned in the paper. The other, with regard to your question of whether there are other deferral tools, yes, there are good deferral tools. I think Learner's book is an excellent sort of is an excellent account of what kind of deferral tools you could employ in making constitutions, right? Which she mentioned that you could pitch, for instance, two contradictory provisions. And now the one reason I'm sort of very interested in directive principle is that it does a lot of work. It also gives framers, sort of an opportunity to sort of mix it with other deferral tools. For example, a directive principle could have a bylaw clause in it. For example, that okay, you have a very sort of you have a broad you could say I don't want to say duty, but then a sort of like the state for example. For the Article 351, the language directive, there could be there could be a bylaw clause that okay, the government has to address this problem, but then they should finalize or give more more concrete form to it. Let's say by 20 years, by 25 years. So you could mix these two. There are other sort of other deferral tools where you put which are explicitly contradictory provision in constitution. So you could say that that the directive principles and some of the directive principles are, you could say, contradictory or at least push against the fundamental rights, right? Now, for example, some could argue that UCC is in a very sort of is almost sort of impossible to enforce, given sort of and you could sort of it will be huge interference with personal laws. Now, another sort of reason for engaging with directive principles, I'm sorry, I'm going beyond your question here, is that directive principles, when you have putting contradictory provision, directive principles are the best place to do so. For example, if you put in because of their non-justiciable character, because they cannot be enforced, if they are contradictory provisions and they are enforceable, that means that means the court has that means the court has has a reason to sort of intervene to force the state to to act on those provisions. But if it's not justiciable, that means there's much broader aspect of a much broader scope for the political organs to interact, to discuss, and and engage with the problem. So if yeah, I think that will be all. Thank you. I'm sorry, I'm speaking for way too long. So there's a comment in the chat box.
Yeah, so Gautam, shall you just take a minute or two to respond to Varsha's question and comments? In the meantime, Ashwani, you can read the question that is for you in the comment box, and then we come back to you.
Yeah, no, just on the deferral point, there are many different strategies that are used for deferral. So one, for example, part 2 of the Constitution, so the citizenship laws, right? They fix certain rules for citizenship at the time of the framing of the Constitution, and are meant to deal with the partition. So the cutoff date is November 19th, 1948 in part 2 of the Constitution. And for issues arising afterwards, they say that Parliament shall frame a law on citizenship. So it's delegated to Parliament. And so then that defers the issue of certain ground rules of citizenship to be left to Parliament at later date. Similarly, for the election commissioners, and this became a controversy this sort of last year, still is, Constitution said that Parliament will frame a law to sort of regulate the conditions of appointment for the election commissioners, and until Parliament frames a law, the President will appoint. So that's again, I mean, and Parliament never then framed the law until now, when the court intervened after some 70 years. So there are many strategies of deferral. You delegate it to Parliament to do it at some point. You do it as non-enforceable directive principles, and so yeah, there are different ways, and part 4 is just one toolbox of deferral, where otherwise things left to the executive to bring into force various kinds of unenumerated powers, they're all there. So many different strategies.
Thank you so much, Gautam. Ashwani, would you like to respond to the question in the comment box?
Right. So the question is with the person wants me to provide more insights into how incrementalism facilitated by constitutional directives align with the dynamic political and social realities of deeply divided societies, which is a very broad question, to be honest. So yes, so when I say the revolutionary approach to constitution making in the paper is that the approach which involves, which sort of wants to solve every problem at the time of constitution making, and by problem I means problems which are, very sort of by what are foundational issues of the state, which could be, for example, here in this case, national language, or some kind of national identity, right? But by that I do not mean a structural foundational issues of the state. For example, you cannot defer whether it should be a federal state or not. You cannot defer whether it will be parliamentary or presidential system or not. So, by that I'm talking about mostly sort of, you could say that it broadly contains national identities, right? How the state recognizes, and that's where sort of the society differs a lot, because we all want to sort of reflect how we see ourselves, or the nation, right? We all want the nation to reflect us, right? And so for example, the people in Hindi will thought that, because it's a nation of sort of, they sort of, they saw Hindi as representing India, right? It's sort of, right? So they wanted sort of Hindi as a national language, right? Now, when I say sort of incrementalism, so there is a sort of you could say, when framers sort of, when a country sort of is making a constitution, there is a sort of understanding that they want to sort of give the constitution want to sort of reflect a unique identity, right, which is sort of universal identity of the nation, right? You could say, right, which is, there's one identity which sort of binds the people, which deeply divides society, could be could be very problematic in the sense that it's difficult to find one sort of identity which could be accessible to all the frameworks or the society at large. So one thing that you could do in that sense is that you give more sort of time to frameworks and to people to see whether not just to see that not just to solve the problem, but also to give, okay, if this problem is important at all, should we, for example, should we have national language at all, is whether it's required or not. And when constitutions are made, they're sort of, it's very sort of, you are obviously functioning within a very limited time frame, right? You often have very limited information as to, for example, at that time, maybe the framers could have benefited from, what exactly they mean, what exactly they mean by Hindustani or Hindi, which it seems that there is sort of more conceptual sort of, if I say, a lack of clarity on what these languages are. So, right, so they are functioning within a very limited time frame with very limited information. So there is a decision and error cost to it, right? So a decision cost in the sense that you have limited time, and and when you are dealing with a foundational issue which is deeply contested, you put in a lot more effort in providing asymmetric information to those involved in decision making, right? Or to engaging with people at large, sort of, because it's them who are being represented, right? So to hearing them, right, whether there's a deep division in the society or whether it's just limited to sort of the Constituent Assembly, which Gautam pointed out earlier. So incrementalism is sort of a good way to sort of, you could say, sort of to cool down the that sort of heightened moment of constitution making, right? And give a more time to sort of to think about the problem. Firstly, if at all it is important, if it's important, how it should be resolved, right? Again, like I said, there's an error cost to it. And error cost could be because they are making a bad decision. And second, if they do make a bad decision, what's the way to, what's the cost to correct that bad decision? So if it's in the constitution, so if for let's say if the constitution maker has resolved the language issue, right, and there will be just one X language as a national language of India, and it later turns out that this is sort of a huge sort of you could say division in this society because of that. They don't sort of, there could be a division. I have to say that we do not, this is not how we see sort of India, right? This doesn't reflect us. Now if that provision needs some kind of correction, whether it's the dilution or it needs to be deleted or amended, the cost of making that amendment is way too high, right? But if you resolve that problem through a political decision making, the cost is way too low, because the cost in making a constitutional amendment and is way too high, right? You have a higher degree of a higher requirement for making for changing. Sorry.
I might have to ask you to wrap up shortly because we are reaching time.
Yes.
And I hate to cut a wonderful discussion short, but could you sum up the position for us?
Yes, sorry for that. Yes, so there. So I mean, you have the error cost is very low, and which you could sort of refer to paper to see a more elaborate argument on that. And yeah, I'll just sort of shut up here. Thank you so much.
Thank you so much, Ashwani, for a very, very rich discussion. Thank you for everyone who's asked a question and enriched the discussion further. Thank you so much, Gautam, for your very, very invaluable comments. And we look forward to more such workshop sessions. Thank you. Thank you, everyone.
Thank you.